Hello, I'm Jaspreet on this side. I'm Company Secretary by profession. This is revision of Companies Act 2013 based on book Saransh by ICAI, Institute of Chartered Accountants of India. I like the graphical presentation of every concept, and we are running through each concept, and I want to give a disclaimer that this is only for revision purpose, and for practical situation please refer to updated laws. And you can watch this at 1.5x speed, at higher speed, for faster learning experience. All the best. So let's start. So far we have covered definition of company, type of companies, then types of companies, then MOA, Memorandum of Association, Articles of Association, and now we are moving to registered office. So registered office of a company, section 12. Now, need for registered office. There are certain countries where a physical registered office is not required. However, in India, we require a physical registered office. It is a physical office capable of receiving and acknowledging all communications and notices. So it is a physical office which is capable of receiving and acknowledging all communication and notices. Domicile and nationality of company is determined by the place of registered office. So nationality of the company and domicile is determined by place of registered office. So all the notices are sent to the registered office of the company. Time limit. A company within 30 days of its incorporation and at all times thereafter have registered office. So once a company is incorporated, then ensure within next 30 days it has a registered office, and uh, thereafter, in case a registered office is changed, then it should be changed simultaneously. There should be no gap. Verification of registered office. Now, within 30 days of incorporation, furnish to ROC verification of registered office. So a verification is filed with ROC within 30 days of incorporation of a company. Labeling of company. Every company shall. Now, labeling of company means the place of registered office is to be shown outside the premises. So it is provided that every company shall paint, affix its name, address of registered office on the outside of every office or place of business in a conspicuous position in legible letters, and if characters employed are not those of the languages in general use of that locality, then also in the characters of that languages. So like if I am at Amritsar and I saw various offices with clearly written name of the company, limited or private limited, followed by uh, its registered office address clear, and also the name is mentioned and address is mentioned in Punjabi language. That is the language which is known by people living in Amritsar. So Punjabi is also there and English is also there. Next is every company shall have its name engraved in legible characters on its seal, if any. So earlier common seal was mandatory. Now if the company is maintaining a seal, then the name should be engraved in legible characters. The next is gets its name, address of registered office and SIN along with phone number, fax number if any, email and website address if any, printed in all its business letters, billheads, letter paper, letter papers, and in all its notices and other official publications. So all in all the official publications, in all the letters, billboards, everything including invoices, name should be there, address should be there, and SIN number should be there mandatorily. SIN is mandatorily to be mentioned. Have its name printed on hundis, promissory notes, bills of exchange, and other prescribed document. So everywhere name should be printed. So this is the requirement of labeling of company's name changed by the company during last 2 years. Now if the company has changed its name during the last 2 years, then that name will also be written along with the present name of the company. So company shall paint or affix or print along with its name the former name or names so changed during the last 2 years. So if there are more than one changes during the last 2 years, then that will also be printed or painted or affixed. In case of OPC, one person company, the words one person company shall be mentioned in brackets below the name of the company wherever its name is printed, affixed, or engraved. So words will be written one person company below the name. One person company is written below the name of the company. Okay, this happens for one person company. Next is change in place of registered office. So can registered office be changed from one place to another? Yes, but there are certain requirements. Number one, we have to check whether this change is within a state. So change is within a state from one city to another, but there is no change of state. Another possibility is that within a state from one ROC to another. So ROC is changing within the same state. And another is that companies being changed from one state to another. Change in place clause section 13, 4, 5, 6 subsections. Okay. So now what happens is, let's take first case where there is change within a state, means within one city to another, but there is not any other change. Special resolution, you have to pass a special resolution for change of registered office within a state, and special resolution is passed by the members of the company, and notice to ROC be filed within 30 days. So ROC will be filed a notice of change of registered office within 30 days. Change in place of registered office within a state from one ROC to another. Now here what happens is special resolution. Okay, so within a state, ROC is only getting changed. Special resolution is to be passed, then permission of regional director is to be taken, and there is requirement of 30 days, 60 days, and 30 days. 30 days, 60 days, and 30 days. So what is the meaning here? That permission of regional director is to be obtained within 30 days. Then means application will be filed to regional director. Then within 30 days, regional director will decide the matter and revert to the company. Means it will take 60 days time to revert that registered office is changed or not. Then after that, within 30 days, ROC is to be intimated that RD has passed its order. Conclusive evidence. Now this will be conclusive evidence of change of registered office within a state from one ROC to another ROC. Next is from one state to another, change in place. Now when there is change of state, then one is special resolution is required, obviously. Next is approval of central government is required. So if change is from ROC to ROC, then RD approval is required. If change is from one state to another, then central government approval is required. And then timeline is given that 60 days will be taken by central government, and then within 30 days ROC will be intimated. Fresh certificate of incorporation. So here fresh certificate of incorporation will be issued on change of registered office. Moving further, subsidiary company not to hold shares in its holding company. Section 19. Section 90 says that a subsidiary company shall not hold shares in its holding company. Now, no company shall hold any shares in its holding company. Clear? Then, either by itself it means it will not hold by itself or through its nominee. Neither its nominee will hold shares. So at times we appoint a nominee to hold shares on behalf of some other person. So neither through nominee nor itself it will hold shares of its holding company. Next is no holding company shall allot or transfer its shares to any of its subsidiary company. Same goes for holding company also. It will also not allot or it will not transfer shares to its subsidiary company. Such allotment or transfer of shares to its subsidiary company shall be void. This will be void. Okay, this is clear. It only says that subsidiary company will not hold shares in its holding company. Next we move to next topic is exceptions to point one. Exceptions to point one is point one was that subsidiary company will not hold shares in holding company. But what if subsidiary company was already holding certain shares and thereafter it became subsidiary at later point of time? Okay, so here also what happens is exceptions where the subsidiary company holds such shares as a legal representative of a deceased member of the holding company. Okay, exception is where subsidiary company is holding shares as a legal representative of a deceased member of the holding company. So it is holding in certain capacity, in certain special capacity, then it is allowed. Where subsidiary company holds such shares as a trustee. So again, trustee is means holding on behalf of a beneficiary. So this is also a special case. So it is holding in a special capacity. Where the subsidiary company is a shareholder even before it became the subsidiary of the holding company. So if it was holding shares prior to becoming subsidiary of a holding company, then also this is an exception. Now, authentication of documents, proceedings, and contracts. Who can authenticate a document, proceedings, and contract? This is very important. A company secretary usually authenticates board resolutions or certain documents, means there can be an agreement, there can be certain internal document of the company which was signed by someone else, but now when it is required to be given, then a company secretary authenticates that this is certified true copy, that yes, this is a document of the company. So he is certifying that yes, this is a document of the company. For example, if a board resolution certified, then yes, it was passed at the board meeting of the company. So it is kind of confirmation, authentication, that yes, this is the true and fair copy of this document. Authentication of documents, section 21. Authentication of documents, proceedings, and contracts. As per section 21, these may be signed by any key managerial personnel or any officer or employee of the company duly authorized by the board in its behalf. So, can only company secretary certify? No. Can CFO also certify? Chief Executing Officer? Yes, CFO also can certify. So he can be a key managerial person. Can Managing Director certify? Yes, Managing Director is a key managerial person. Personal. Can Whole-time Director certify? Yes, Whole-time Director is a key managerial personnel. Or apart from these, if by a board resolution someone is authorized to authenticate certain documents, then we pass a resolution that they can do this, they can sign certain documents on behalf of the company and do any other act incidental thereto. So we authorize certain officers or employees of the company who are duly authorized by the board in this behalf. Now question comes, these are officers of the company, this is an important word. So KMPs of the company or officer or employees of the company, at times we authorize an outsider for certain activities, so they cannot be authorized to authenticate documents of the company. This is important to remember. As per section 251 to subsection 51, key managerial personnel in relation to company means who are covered in key KMPs: CEO, Chief Executive Officer or MD, or the manager. Then company secretary, then whole-time director, then chief financial officer. Such other officer or more than one level below the directors who is in whole-time employment designated as key managerial personnel by the board. So board can designate who is one level below the directors. So board can designate a person to be a KMP, such as other officer as may be prescribed. Officer of the company. Okay, this is clear. Who can authenticate the documents? It is important. Now, a company secretary is signing to authenticate a document that this was done in the past. Suppose if there is an agreement, a fresh agreement being signed, can company secretary sign on that? Only when he is duly authorized by board of directors to sign certain agreements on behalf of the company, then it can do. Prospectus and allotment of securities and private placement. Now, issue of securities. Okay, so I think that this we should cover in our next portion. Today we covered registered office, change of registered office, authentication of the documents, and subsidiary will not hold shares in the holding company. I hope this was valuable for you, and this is a disclaimer that this is only for revision purpose. Thank you.